This course will cover practical considerations when forming your medical practice in Florida. We'll cover entity selection and formation, enrolling in Medicare, and obtaining your business license. The course objectives will be to outline various entity selection options in order to establish your medical practice in Florida, and to discuss the process for enrollment in the Medicare program, obtaining a federal employer identification number, and obtaining appropriate local business licenses. So the first question is, why do you even need a practice entity? The short answer is liability protection. It separates the assets of the company, like accounts receivable, tables, chairs, supplies, things of that nature, from personal assets of the owner or owners of the company, or in this case, the medical practice. An entity is liable for its own acts, and an individual is liable for his or her own acts. And again, the purpose of the entity is to separate those two from each other. So in English, what that could mean is that it separates your personal assets, the things you own individually, from the company's assets. So if there's a lawsuit against the company, only the company's assets are at risk. An exception to that would be, as we'll get to in the next slide, a malpractice lawsuit, which often in that case, what happens is the individual physician is sued because, again, the physician has acted there, as well as the company for its involvement, whether it's for sometimes negligent hiring, things of that nature that plaintiff lawyers may sometimes use. A couple of examples of why it would be important to have a practice entity would be for vendor contracts, for example. Any vendor contract, we'll stay away from insurance contracts for just a second, but vendor contracts, anything from the cleaning company to paper shredding or anything like that, just your business vendors. Again, you don't want your personal assets at risk for a breach of contract or something of that nature. So a perfect example of why you would want a contract with the entity and why you would want to have an entity. From a legal perspective, an entity is treated like a person. An entity can sue, it can be sued, and therein lies that separation. Again, one difference would be, example of a difference would be a malpractice lawsuit when oftentimes both the individual and the company or the practice are brought in, but of course that's what insurance is for, and we'll talk about that a little bit later. Also, if billing for professional medical services through the entity, the payers will look to the entity, typically, Medicare included, as opposed to looking to you individually. So that would be a huge benefit. If there's ever an issue like an audit or something of that nature, you would want it to be more focused in general on the practice and less so on the personal assets of one physician or all physicians in the practice. Also, there are some potential tax benefits. There are certain write-offs. Without getting into too much detail, there is a possibility or an opportunity for certain write-offs, but of course those should be analyzed with your CPA and with your attorney. Entity selection is something that we'll cover shortly that should also be discussed with both. One important Florida law of significance when it comes to entity formation and selection is the Healthcare Clinic Act. It's somewhat unique to Florida. Many states have what's called a corporate practice of medicine statute. And the simple version of that would be, or the simple explanation of what that is that a non-physician or non-group of physicians cannot own a medical practice. So for example, there are exceptions, of course, in most states for hospitals and other not-for-profits, but the concept being, at least at its core, that business people not own a medical practice. Florida has sort of a hybrid version of that called the Healthcare Clinic Act. It says that all clinics, any clinic which is defined in the statute, is required to have a license. A clinic is defined as any entity where healthcare services are provided to individuals which tenders charges for reimbursement for those services. Now, the important component of that, of course, is what does tenders charges for reimbursement mean? That has been interpreted to mean anything that isn't just pure cash. So any insurance, Medicare, Medicaid, TRICARE, any source of payer, that's going to trigger this law. The reason physicians may not know about this is because there is probably the most commonly used exemption. There are a series of exemptions for this, just like in other states, and the most commonly used one is for for an entity that is wholly owned, 100% owned by licensed physicians or by the physician and a parent, child, spouse, or sibling. There are many nuances inside of this statute that, again, are important to discuss with a knowledgeable attorney on the subject. We'll get a little bit into the importance of documentation later. And this is one space where it is important to have documentation surrounding your entity that is appropriate and is sensitive to the Healthcare Clinic Act. So if there are changes in ownership and things of that nature within the practice, that the Healthcare Clinic Act is taken into account and doesn't create major problems for the practice. This is very important because the penalties for violation of this statute are significant. There are multiple $1,000 fines per day for violation. You're also prohibited from billing if not in compliance. So in other words, this can basically shut down your medical practice. So very important to be cognizant of this and to make sure that your practice corporate governance documentation, such as operating agreement or shareholders agreement, are drafted in a way that is sensitive to this document. There are ways to be sensitive to the statute and to address it within your documentation. So let's turn now to the entity selection and the most common types of entity choices for physician practices in Florida. There are other types of practice or entity options, but these would be the most common. First, you have the limited liability company. Second, you have the corporation. And then third, you have the professional limited liability company / professional corporation, meaning it's the professional version, so to speak, of either the limited liability company or the corporation. You'll note that we're going to focus mainly on the limited liability company and the professional limited liability company, and we'll get into why. But I did want to make sure that we do cover the most common types that you'll see. And these can work for solo practices or for practices with more than one owner. So why do I want to focus on the limited liability company? Well, it's all about asset protection, which is, again, sort of the main purpose behind having an entity in the first place. A few years ago, the Florida Supreme Court came down with a case, which we all call OLMSTEAD, which was SHAUN Olmstead versus the Federal Trade Commission. And to make a long case short, the Florida Supreme Court made clear that a creditor, meaning one who is owed money, of an LLC, a limited liability company that has more than one owner, and a member is an owner in an LLC, is limited to what's called a charging order. And a charging order essentially means that the creditor is limited only to distributions from the company, meaning they cannot get at assets of the company, they cannot get at compensation that's paid to employees of the company. They can only get to distributions if distributions are even made. Many companies, including medical practices, don't necessarily make distributions. Compensation is paid out in other forms. So this can obviously be an asset, no pun intended, to a medical practice that has a creditor. So this is good preventative care, for example, when it comes to asset protection for medical practice. So that's why we tend to lean towards the LLC and have been doing so even more over the last chunk of years since this case came down. I want to make sure we distinguish that the Supreme Court spoke only to entities that have more than one owner. So there is silence on what happens, relative silence on what happens with one owner, but it is clear as to more than one owner that, again, a creditor would be limited to a charging order, which would limit the financial recourse that a creditor would have if there was ever a liability attached to the practice entity. So certainly can be helpful. So let's distinguish a little bit between professional entities and non-professional entities, regular LLCs and corporations. So first on a professional corporation, and this quote is directly from the statute, and you see sort of the distinction is that highlighted language. It's one or more individuals, professional corporations, or professional limited liability companies duly licensed or otherwise legally authorized to render the same professional services is permitted to organize as a professional corporation. One item that the legislature in Florida has not spoken on, and neither have courts, the statute is not clear as to whether MDs and DOs, for example, could form an entity and practice together. Now we know there are many out there doing it, we've never seen an issue with it, but it's interesting to note that the language does make clear that the individuals or entities would be duly licensed or otherwise legally authorized to render the same professional service. One would think that the intent was that it would be okay for MDs and DOs to be owners in a practice together, but never tested and not super clear based on the language in the statute. The same thing goes for professional limited liability companies. Generally, the only change is instead of using the word shareholders, we see the word members, which again is the difference between just titling an owner in an LLC is considered a member and an owner in a corporation is considered a shareholder. So let's cover a little bit more on the professional limited liability company and why many healthcare lawyers consider it the entity of choice for the typical physician practice. In addition to the protections that we mentioned before that are provided by a limited liability company that has more than one owner, there are a few things that the professional limited liability company can also offer to a medical practice that in and of themselves can be helpful. We mentioned the Healthcare Clinic Act, and as you may recall, I mentioned that the primary exemption that applies to physician practices is an entity that is wholly owned by physicians or by physicians and certain members of their families. Well, if you'll recall, in the definition of professional limited liability company, we mentioned that the professional limited liability company, by its definition, can only consist of owners who are duly licensed and providing the same services. That would work perfectly for a law that requires, as an exemption, whole ownership or 100% ownership by licensed physicians. Similar concept as it applies to the anti-kickback statute under federal law and similar versions of Florida law. There are certain safe harbors to these laws, and they go beyond the scope of this discussion, but very, very important laws for physicians anywhere in the country. Florida is no different. And the safe harbor to the anti-kickback statute for investments requires the practice to be, again, 100% owned by licensed practitioners. So again, by its own nature, the professional limited liability company requires compliance. There is also the potential, though it gets a little bit complicated, for enhanced liability protection for the individuals in the entity. The statute says that any officer, agent, member, manager, or employee of a corporation or limited liability company that is a professional corporation or professional limited liability company is personally liable, meaning individually liable as an individual as opposed to the entity, and accountable only for negligent or wrongful acts committed by that person or by any person under that person's direct supervision and control. So in the healthcare context, that can mean nurse practitioners and physician assistants if direct supervision and control is required. But you can see that there may be other people involved in the entity who may not be under the direct supervision and control of the owners. And so there may be some additional personal liability protection for owners of a professional limited liability company. So the takeaway, I think, from here would be that you're going to get the benefits of asset protection with either a corporation or a limited liability company. You will get a little bit of potential additional protection from a limited liability company in Florida certainly if there is more than one owner in your medical practice. Those are the basic takeaways, of course. These types of things should be discussed and analyzed with your professional advisors. There are other types of entities that may fit better, but for the typical medical practice, these would be the most common. So a few tax considerations to discuss, and as I always say, the only thing more boring than being a healthcare lawyer is being a tax lawyer, so I will only touch on these. But the main options here are S corporation and partnership in terms of tax election. There's also C corporation, but for a few reasons, that is not something that the typical medical practice selects nowadays. However, this is something that, of course, again, should be analyzed with your professional advisors, such as your accountant and your attorney. A couple of benefits, or the main benefit for an S corporation or being taxed as an S corporation, which, again, I'll mention is an option whether you're an LLC or a corporation. There are no payroll taxes on distributions, so it is an area, if done properly, that can save you on some taxes. It is important, though, and that sub-bullet is very important. It does not mean you can avoid paying yourself compensation. The IRS says that there needs to still be reasonable compensation paid. So as a physician, obviously that means you cannot have an under-market compensation, try to dump all of your excess money into distributions and hope that the IRS is going to be okay with that. If you get audited, that can create an issue for you. The main benefit to partnership is flexibility. And it can be stated that it's more flexible from a partnership perspective, or there's less flexibility as it relates to being an S-Corp. We'll stick to the partnership angle of this. There is more flexibility in the manner of distributions and tax allocations that can be made by the practice. For example, an S-corporation requires that distributions be made pro rata, meaning in accordance with ownership percentage. And there are certain healthcare laws that would require that too. However, there are certain elements of healthcare law that don't require that. And in a partnership, it is not a requirement that distributions be made pro rata, in other words, based on ownership percentage. The same thing goes for classes of ownership. In an S-corporation, the S-corporation is not permitted to have multiple classes of owners, if you've heard of Class A and Class B stock, for example. There are distinctions you can make in voting and non-voting, but those are the only distinctions that can be made. So again, there's additional flexibility when it comes to a partnership as it relates to classes of ownership, which we do often see in medical practices. There's also more flexibility when it comes to restructuring in the future. If you have eyes towards growth, there will be much more flexibility for people like me who deal with practice restructuring when dealing with a partnership as opposed to an S-corporation. Without boring everyone to sleep, I will leave it at that as it relates to restructuring. And I can't emphasize enough that you can, if you can't tell already, these are very important to be analyzed on a case-by-case basis in terms of not only what the practice is intending to do now, but where it intends to go in the future. Some practices want to stay, some individuals want to stay solo practitioners their entire careers. Some have eyes towards, becoming 100 physician practices. So all of these things are important when analyzing the appropriate entity as well as the appropriate tax status. A little bit about the important documents for each of these kinds of entities. For an LLC or the PLLC, which is the Professional Limited Liability Company, we have articles of organization. Those are the documents that are filed with the state of Florida to establish your entity. I always notice that the most stressful component of that is typically that, who decides on what the name is going to be. There's always lots of discussion surrounding that. But that gets filed with the state of Florida, as I mentioned, and that is what actually puts your entity into existence. The other document that relates to the corporation that is very important, of course, is the operating agreement. That tells the story of ownership of the LLC or of the medical practice. Everything from voting to ingress and egress from the practice and most things in between. You may recall that we talked about the Healthcare Clinic Act and issues that can arise as a result of the exemption that requires 100% ownership. I mentioned that this deals with ingress and egress of ownership percentage. Well, that applies for things like not just termination of employment in the practice, but death, disability, and other what we call triggering events. So very important for entities that have more than one owner. Now, there's not, operating agreements for single member LLCs, meaning one owner, as well as those for more than one. For those that have more than one, it is important in the healthcare context, in the physician practice context, for these documents to be drafted in a way that is sensitive to all healthcare laws that deal with profit distributions appropriately because of those pesky fraud and abuse laws like the Stark Law and the anti-kickback statute, as well as state laws such as Florida's version of the Stark Law and the anti-kickback statute, as well as the Healthcare Clinic Act that appropriately deal with ownership percentages upon death, disability, loss of license, and things of that nature. Because these things, while they may come across unimportant and very weedsy and detail-oriented, they are the types of things that can make or break your medical practice depending on what happens in the life of the owners and the employees. Also, of course, employment agreements are important. Every owner in a company is typically also an employee. We may forget that, but employment agreements are very important for several reasons. One, any contract is important because when drafted properly, they minimize the risk of pesky lawsuits, because having things in writing that are signed that are clear avoid he said, or she said, he said, or any other amalgamation of that type of disagreement. That's when people end up in court. Employment agreements are also important in Florida because they can help afford the physicians in certain circumstances wage protection under Florida law, which is, of course, again, another example of where asset protection can come into this. And certain members, head of household in Florida, and there's a definition for that, is actually afforded wage protection in Florida, subject to certain caveats. So important to have employment agreements in place as well. For a corporation or a professional corporation, you have the Articles of Incorporation, which serve the same purpose as the Articles of Organization. That's the document that is filed with the state of Florida to actually form the entity. The Shareholders Agreement, which includes what we call buy-sell provisions, sometimes you see these also called buy-sell agreements, cover, along with the bylaws, which is the next bullet, sort of cover what's in the operating agreement in an LLC. Everything from voting to ingress and egress, valuing the percentage, or excuse me, the value of the ownership interest. That goes for both LLCs and corporations. Those are contained in these ownership documents as well. There are a bunch of different options when it comes to valuing shares in a corporation or membership units in an LLC. Those are also to be discussed and analyzed with accountant, attorney, and other advisors. Lots of different options. Also need to be sensitive there to healthcare fraud and abuse laws to make sure that the valuation is compliant. Employment agreements, of course, are also important in the corporation. So you see, although documents have different titles and may cover slightly different concepts, at the end of the day, they serve very similar purposes regardless of the entity, and I cannot stress enough the importance of these documents in the life of your practice. So turning now to some of the other identification numbers that are needed. Now that you've got your entity, it's formed, you have these wonderful documents in place that hopefully end up collecting dust in a file cabinet somewhere because everybody's happy, but if not, they can come out and be used. But what else do you need? Well, let's talk about a few of these other items. One is what's known as an EIN, or an employer identification number, or some people call it a tax ID. That is your 9-digit identification number that the IRS uses to identify you. Here this ends up on any filings that you make with the IRS. If you have employees, you need an EIN. If you have more than one owner, you also do. If you have formed an entity, your accountant or your lawyer can assist you with getting one. Most can help out if you ask. Also, if you want to do it on your own, the application can be found on the IRS website. It again, though, I cannot stress enough that it is important to make sure that what you file matches what has been created for you in terms of your entity. And S corporation election or partnership selection, all of these things are absolutely essential. And this is one area where it's very difficult to unring the bell when certain elections are made. So it's important to get this right the first time. Relatively run-of-the-mill or easy for your advisors to assist you with, so it's an important thing to talk to them about. On the healthcare side of things is the NPI, or National Provider Identifier. This is a 10-digit number that is issued by CMS, a very similar purpose. This is what is used to identify you for billing purposes more than anything else with CMS, but for other identification purposes as well. But most important on a day-to-day basis for you is this is your identifier when you're billing CMS. So who is required to obtain an NPI? Any HIPAA-covered entity has to obtain an NPI. A detailed discussion of HIPAA goes outside the scope of this discussion. However, the short answer is that any medical practice that does any third-party billing electronically, which is pretty much every medical practice in Florida for the most part, would be considered a covered entity and would need an NPI. So very important for your Medicare billing. The answer is yes. If your question is, does my practice group also need one? A separate one would be obtained for the practice entity. The best way to obtain it is, again, online. It used to be far more complicated because everything was on paper, but CMS has made it a little bit easier. You can go to the CMS website and use the NPPES system to obtain your NPI number. Medicare enrollment, that's separate than your NPI, actually enrolling as a provider in the Medicare program. Physicians are covered by Part B of Medicare. Part A is hospitals, home health agencies, and a few others. Part B is a few others, and including physician groups and individual physicians. you have to complete what's called the Form 855B. That is the Medicare form for enrollment for physicians. It covers initial enrollment, revalidation, change of information, and change of ownership. Of course, initial enrollment is what you would use at the beginning. These other things like revalidation, change of information, which include changes of office location and things of that nature. Also changes of ownership when you add or subtract an owner, when you sell, things of that nature. All of this is done through the 855B. And changes are required, and you must keep current. It's actually a violation of Medicare rules for failure to keep current. A more detailed discussion of that can come with your attorney or other advisor when it comes to your Medicare billing. The effective date, much like the IRS actually, the effective date of your enrollment is the date of filing. So in other words, there's retroactive coverage, so to speak. However, it is important to just hold your billing and wait to make sure that you do get approved. You do not want to send anything in because until you are approved, you do not get that retroactive coverage. So rule of thumb, file up to 60 days prior to the date that you are to commence providing services. That will at least get you, hopefully on a bad day, at least get you close to the same day when you would actually commence services. PECOS is actually a bit newer. It's only a few years old, and it's been refined a few times by CMS and improved. It is the online web-based enrollment system. So we mentioned the 855B. That's been made more electronic through the PECOS system, and that can be used for initial enrollment. And we again have seen a dramatic improvement over the last few years in the PECOS system. So we'll turn to occupational licenses as well. As you know, every physician in Florida must be licensed in order to practice medicine. Chapter 456 of Florida law applies to all healthcare practitioners. Chapter 458 applies to MDs, and 459 applies to DOs. So that is for your individual license to practice medicine in Florida. Of course, your practice entity, depending on the county, may also need an occupational license, so a license to conduct business. That's more of a locality-specific item. So if it is required to obtain an occupational license, again, that would be the best way to determine whether your county requires that would be to go online to your county's revenue tax collector website and see what those requirements may be.